Good morning, followers. Thanks. Howdy. It's Professor Suresh. Happy to be back again for my next video, 10th one by self so far. And this time I'll explain the basics of patents, types of patents, and patent application process in India. At the outset, I need to admit that I'm not an expert to really publish videos on different various topics, but I learned through articles and digital books, e-books, available on World Wide Web. Hence, those authors, editors only deserve the credit. What prompted me to publish this particular video is normally people who have already applied for patents do not divulge the details to prospective patent applicants, maybe because they consider them as the competitors or they lack the confidence in themselves. A patent is a form of intellectual property that gives its owners the legal right to exclude others from making, selling, and importing an invention for a limited period of time in exchange for publishing and enabling public disclosure of the invention. Under World Trade Organization's WTO TRIPS, trade-related aspects of intellectual property rights agreement, patents should be available in WTO member states for any invention in all fields of technology, provided they are new, involve an inventive step, and are capable of industrial application. The word patent originates from the Latin word pater, P-A-T-E-R-E, which means to lay open, that is to make available for public inspection. It is a shortened version of the term let us patent. It's all Wikipedia definition. Term of every patent in India is 20 years from the date of filing of patent application, irrespective of whether it is filed with a provisional or complete specification. However, in case of applications filed under PCT is Patent Cooperation Treaty, the term of 20 years begins from the international filing date accorded under PCT. PCT is an international patent law treaty concluded in 1970. It provides a unified procedure for filing patent applications to protect inventors in each of its contracting states. A patent application filed under the PCT is called the International Application or simply PCT application. On an average, it currently takes between 4 to 6 years from filing an application in India to getting a patent in India. Types of patents are utility patents, design patents, plant patents. In India, an invention means a new product or a new process that involves technological advancement and or has economic significance, which makes that new product or process non-obvious to a person who is skilled in the technology in which the product or process belongs. Additionally, the new product or process should be capable of being made or used in an industry for it to qualify as an invention. In India, Section 3 provides a lot of exclusions. They are 1. An invention which is frivolous or which claims anything obviously contrary for well-established natural laws. Example, perpetual motion machine. 2. An invention, the primary or intended use or commercial exploitation of which would be contrary to law or morality or which causes serious prejudice to human, animal or plant life or health or to the environment. Example, a method of hacking into email accounts. 3. The mere discovery of a scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature. Example, Einstein's relativity theory E is equal to mc squared, which people are trying to disprove, Okay. 4. The mere discovery of any new form of a known substance which does not result in the enhancement of the known efficacy of the substance or mere discovery of any new property or new use for a known substance or of the mere use of a known process, machine or apparatus, unless such process results in a new product or employs at least one new reactant. This exclusion has been at the forefront of most debates in the pharmaceutical sector. 5. A substance obtained may a mere admixture resulting only in the aggregation of the properties of the components thereof or a process for producing such substance. Example, mixture of sugar and colorants in water which only produces aggregation of properties and synergistic properties. 6. The mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way. Example, a known type of touch connected in a known type of pen. Note, both the pen and the touch work independently of each other. 7. A method of agriculture or horticulture. Example, a method of growing plants. 8. Any process in the medical, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings, or any process for a similar treatment of animals to render them free of disease or to increase their economic value or that of their products. Example, process of carrying out the surgery. Note, processes in this case are not considered inventions. However, systems and apparatuses are still considered as patentable subject matter. 9. Plants and animals in whole or any part thereof other than microorganisms but including seeds, varieties and species, and essentially biological process for production or propagation of plants and animals. Example, cloning of animals. 10. A mathematical or business method or a computer program per se or algorithms. This exclusion has been debated to great lengths. The debate is essentially because of the computer program per se exclusion. Note that not all software related inventions are considered as computer program per se. Hence the debate is relating to what should be considered as computer program per se and what should not be. 11. A literary, dramatic, musical or artistic work or any other aesthetic creation whatsoever including cinematographic works and television productions. Example, movies, poems, etc. 12. A mere scheme or rule or method of performing mental act or method of playing game. Example, method of playing chess. 13. A presentation of information. Example, presenting information in the form of a graph as done in PowerPoint presentation and all that. Okay. 14. Topography of integrated circuits can see protection under Semiconductor Integrated Circuit Layout Designs Act. 15. An invention which in effect is traditional knowledge or which is an aggregation or duplication of known properties of traditionally known component or components. Usage of Nilgiri oil for reducing age is an example. In Guru Parampara, the traditional way, the Guru or the teacher acquires the knowledge from his or her Guru, Adi Guru or Acharya, refines it by applying their expertise and experience and passed it on to their disciples. The concept those days was, let noble thought come to us from everywhere. Let all living beings live happily, free from fear of death and disease. Is that happening now? Okay. This is no longer true since everybody wants to make as much money as possible from all potential opportunities. Innovation has been a vital component of not only American success stories and also other developed nations too. Patents in force worldwide grew by 6.7% to reach 14 million in 2018. Around 3.1 million patents were in force in the US, followed by China 2.4 million and Japan 2.1 million. This is 2018. But in 2019, China surpassed USA as the top source of international patent applications filed with World Intellectual Property Indicators, shortly WIPO, amid another year of robust growth for the organization's international intellectual property services, treaty adherence activity, and revenue base. As per the patents grants for top 10 officers, China leads with 432 147 patents, USA with 307 759 patents, Japan with 194 525 patents, followed by other nations. India with 13,908 patents is in 10th position. Wow! Intellectual property right (IPR) can be assigned or licensed for financial benefits. Substantial conditions for registration of design patents are 1. Design should be aesthetic, appealing to the eyes. 2. Design should be new or original. 3. Design should not be contrary to public order or morality or does not contain obscene or scandalous matter. 4. Only the features of shape, configuration, pattern, ornament, composition of color or line or a combination thereof apply to any article, whether 2 or 3 dimensional or in both forms by any industrial process. Documents necessary for applying for design registration are 1. The application should be filed in the prescribed form 1 with the prescribed fee of rupees 1000 for individuals actually. 2. Representation of the article clearly showing all the features of the design by different views and stating the names of the views below each view on durable paper should be filed in quad replicate, 4 copies. The statement of novelty and disclaimer, if required, in respect of mechanical action, trademark, word, letter, numerals, and similar design in other class should be endorsed on each copy of the representation sheet, which should be signed and dated. 3. Power of attorney if necessary. 4. Normally it is better to go through some attorneys because there are legal issues involved. 4. Priority documents if claimed under Paris Convention or WTO. Designs filing fee is rupees 1000 for individual, that's what I said before, rupees 2000 for small firms and rupees 4000 for large firms. For these fees keep changing every now and then, so better check it. For renewal of design, the charges are double the design filing charges. Design patents are valid for 10 years in India from the date of registration, but in case where a claim to priority has been allowed, then duration is 10 years from the priority date. This initial period is extendable by a further period of 5 years by applying as per the rules. A trademark is any sign which can distinguish the goods of any trader from those of another. Sign includes words, logo, pictures, or a combination of these. A trademark is used as a marketing tool so that the customers can recognize the product of a particular trader. To register a trademark, the mark must be distinctive, not deceptive or contrary to law or morality, and not identical or similar to any other marks for the same or similar goods. In developing countries like India, traders indulge in cheating by a similar name, logo, which is deceptive as per the rules and regulations. But people get away. Spurious products are also sold in the market as original products. Copyright is a protection offered to the works created by the authors of literary, dramatic, musical works, producers of cinematic films and sound recordings. Ideas, facts, titles, and slogans can't be copyrighted. Term of copyright is 60 years either from the date of the death of the author, or 60 years from the date of publication. Piracy is illegally copying some other's works without their legal consent. Piracy is also very much rampant in countries like ours. Geographical indication, GI, is an indication which identifies goods as agricultural, natural, or manufactured, originating or manufactured in the territory of a country or a region or locality, where a given quality, reputation, or other characteristic of such goods is essentially attributable to its geographic region. Example, Tirupati Laddu, Kanjivaram silk sarees in India. Intellectual property evolution. Intellect, from intellect, property, then right. 1. Idea is converted as expression, then copyright. 2. Idea, innovation, invention, then patent. 3. Idea, quality, identify, trademark. 4. Idea, appearance, then design. 5th one, idea, keep confidential, discreet, no disclosure, trade secrets. All these things are interlinked, that's why I talked about it. All these are interlinked to patent. Okay, trademarks, trade secrets, copyright, whatever. An Indian patent can't be enforced outside India. No person resident in India can first file his or her application outside India. Two options available are file the application first in India and wait for a period of 6 weeks or more, and thereafter file the application outside India. 2. Obtain prior permission for filing an application to patent first outside India. It is advisable to file for international patent under PCT invention. PCT. Invention must not be 1. Published in India or elsewhere. 2. In prior public knowledge or prior public use within India. 3. Claimed in claims in any specification in India. Patents related to defense must be referred to central government under Section 35. Secrecy directions to be periodically reviewed under Section 36. The first legislation in India relating to patents was the Act 6 of 1856. Fresh legislation for granting exclusive privileges was introduced in 1859 as Act 15 of 1859. In 1872, the Act of 1859 was revisited to provide protection related to design and renamed as the Patents and Designs Protection Act under Act 13 of 1872. The Act of 1872 was amended in 1883. It is 16 of 1883 to introduce a provision to protect the novelty of the invention, which prior to making the application for the protection was disclosed in the Exhibition of India those days. In 1911, the Indian Patents and Designs Act 1911, Act 2 of 1911 was brought in, replacing all the previous acts. This act brought patent administration under the management of Controller of Patents for the first time. After independence, it was felt that the Indian Patents and Designs Act 1911 was not fulfilling its objective. So a committee was set up in 1949 and they came up with the recommendations to amend this act in 1950, Act 32 of 1950 in relation to working the inventions and compulsory license revocation. In 1957, Justice N. Rajagopala Iyengar committee was appointed by Government of India, and in 1967 an amended bill was introduced which was referred to a joint parliamentary committee, and on the final recommendations of the committee, the Patents Act 1970 was passed. This was amended in 2002 and came into force on 20th May 2003 with the introduction of the new patent rules. Patent system in India is administered under the superintendence of the Controller General of Patents, Designs, Trademarks, and Geographical Indications. It is shortly called as CGPDTM. Appointed under subsection 1 of section 3 of the Trademarks Act 1999. CGPDTM functions under the Department of Industrial Policy and Promotion, Ministry of Commerce and Industry. The office of CGPDTM is located in Mumbai. There are 4 patent offices in India. Head office is at Kolkata and other patent offices are located in Delhi, Mumbai and Chennai. Office of the Controller General of Patents, Designs and Trademarks is located at Baudik Sampada Bhavan, SM Road, Antop Hill, Mumbai 400037 4022 2413 2735. Email ID cgoffice-mh@nic.in. Patent Office Chennai is located at Intellectual Property Building, GST Road, Gindi, Chennai 600032. Phone number 044-2250-2080. Email ID chennai-patent@nic.in. An application for a patent for an invention may be made by any one of the following persons, either alone or jointly with another. 1. True and first inventor. 2. True and first inventor's assignee. 3. Legal representative of deceased true and first inventor, his or her assignee. I mentioned the fees and all before, but always it is better to check the latest applicable fee for filing, since these keep changing from time to time. Okay, check the addresses, email ID also. This is the latest information I got from the net. I know this is a lengthy presentation. The topic is such, and I have presented only the vital information for prospective applicants. Let me wind up here. Do not venture out unless otherwise really necessary. The rest